Welcome to Video Tips. This is Howard Stross. Today I want to talk to you about a topic that is called funding a trust. It's a funny sounding word, but it's really no laughing matter, because without properly funding your trust, you will really not have a trust that will work for you to achieve your objectives. Most people, when they do a revocable living trust, it's for one of the major purposes is for avoiding probate and also minimizing the possibility of getting into a guardianship if the person who creates the trust were to become incapacitated. And you might be surprised at the following statement I'm going to say, but that most estate plans don't work. And there's a reason for it. And the reason is they're not funded, or maybe they're only funded with one or two assets. And by funding, what I mean is that when you're done with your trust, you've signed it, it's been properly witnessed in the manner called for under Florida law, and a lot of people think they're done, but really they've just begun. And we will be posting a couple different articles on our blog about this, and I'll also reference an article that you can look at too, not for the purpose of self-funding, but for the purpose of really emphasizing how important this is. Funding is merely taking the ownership of your property and transferring it from your name to the name of the trust, unless there's certain types of property, like life insurance is an example, and there's some annuities and IRAs. Now, though the ownership won't be transferred for those, but the beneficiary designations can be changed in some cases to the name of the trustee of your trust. That's, in other words, you transfer it from you as a person to you as the trustee of your trust in most revocable living trust plans. But the same process applies if you're doing an irrevocable trust. You still have to put some gas in the gas tank to make the car go down the road, and the same with the trust. If you don't have anything in the trust, it's not going to do anything for you. So I want to emphasize that, and I want to do it by giving you one example. Let's say that you have, and this is about the simplest example I can think of, and we'll give you more later in later videos. But you can transfer the asset of your checking account. It's in your name. Or maybe it's in your name and your spouse's name. And it can be changed so that it's still in your name and you still have complete control, but instead of just your name, it's your name and you as trustee of your trust, along with your spouse. And it can be done at any bank. They know how to do it. They're used to it. But it has to be followed up. You actually have to do it. And you have to sign signature cards. You do not have to get new checks. You don't have to change your account numbers. You don't have to do anything other than just signing some paper. It's not difficult to do. You just have to do it. And you might be asking yourself now, well, what if I don't do this? Well, if you don't do it, you're not going to avoid probate. You're not going to minimize the chance of having to have a formal guardianship, and you're going to defeat one of the major purposes of having a trust. So please remember this. This is really important. In fact, next to having a properly drafted trust, this is the most critical step in having a trust-based estate plan. Thanks for listening to Video Tips, and remember, if you want to fund your trust, if you haven't done it, seek the assistance of an estate planning attorney to guide you through the process. That's all for now.